Okay, we're live. Hello, good evening, and welcome back to the Law Entrance YouTube channel. Today's class is on legal reasoning, and today's topic is going to be a foundational sort of a session. Today is a session where we would learn about what exactly are principal fact based questions. So, in a lot of law entrance exams, talking about ALET, talking about SLAT, you would encounter principal fact based questions rather than paragraph based questions. So, we'll look at what exactly are principal fact based questions, what is the best way to approach them, what are the important things to study in order to be able to solve these questions, and lastly, we'll do some practice questions as well. So, that is the agenda for today's class. Let's begin without any further delay. So let's talk about the first point. What exactly are principal fact-based questions? Now, when you say the word principle, what do you understand? Principle means a set of guidelines, a set of rules, a set of instructions which you have to follow. Correct? That is what principle means in common parlance. But in the legal parlance, when you talk about questions of legal reasoning, principle means a legal principle which may or may not be derived from an actual law, from an actual statute, from an actual provision of Indian legal framework, or even not even Indian legal framework. It could be a foreign legal framework as well. Now, the next question is the principle always aligned with what is the existing law? For example, अगर मैं बोलूं कि murder is not an offense under IPC. That is my principle. Can this be a valid principle? Now you might say that IPC तो चलो हट गया, BNS कह लो. BNS के under murder is definitely a crime, it's definitely an offense. How can you say that your principle is murder is not an offense? It does not sit well with common sense or logical reasoning or even the current law. But that is the thing, that is a disclaimer, that is a caveat which you have to keep in mind, that principle आपका कुछ भी हो सकता है. Principle is just you could say, हिंदी में जैसे कहते हैं ना पत्थर की लकीर, कि बोल दिया कह दिया ना, बस कह दिया, तो मतलब यही फॉलो करना है. प्रिंसिपल आपको क्यों दिया जाता है? फर्स्ट ऑफ ऑल, व्हाट इज द पर्पस बिहाइंड प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस? डू दे वांट टू टेस्ट योर नॉलेज ऑफ लॉ? नहीं, बिल्कुल भी नहीं. दे वांट टू सी हाउ वेल यू कैन अप्लाई a law, a given law to a given fact situation. यानी कि आपकी critical thinking skills are being tested through principal fact based questions. तो इसलिए law वो आपको बताते हैं in the form of a principle, and वो principle आपको apply करना होता है in a certain fact scenario कि ऐसा ऐसा हुआ, ऐसी ऐसी कहानी हुई, अब बताओ ये वाला law किस तरीके से apply होगा. So that is the objective, right? Coming back, माई पॉइंट वॉज दैट प्रिंसिपल जरूरी नहीं है कि आपका एक्चुअल लॉ से कोरिलेट करे या एक्चुअल लॉ से अग्री करे. इट कैन डिसअग्री विद एक्चुअल लॉ, एंड आपको इसको ट्रू मान के ही क्वेश्चंस को सॉल्व करना पड़ेगा. सो इफ योर प्रिंसिपल इज सेइंग मर्डर इज नॉट एन ऑफेंस, यू वुड अज्यूम, you would believe, you would trust that murder is not an offense for that question, of course, not in real life. Okay, so that is the basic thing about principal fact based questions. The next thing is best way to approach. As we were talking that principle is your Bible, principle is supreme, principle से ऊपर कुछ भी नहीं है. But not just that, you also have to look at some other things like you have to understand that you have to choose out of 4 options A, B, C, D. कई बार ऐसा होगा कि आप एक या 2 ऑप्शंस एलिमिनेट कर पाओगे, बट 2 ऑप्शंस बचेंगे which seem to be both aligning with the principle, both seem to be like the correct answer. Now you would have to choose the most relevant answer, the most appropriate answer. There might be 2 correct answers, but उसमें से एक ज़्यादा relevant होगा, एक कम relevant होगा. वो कैसे पता चलेगा? Of course through practice, but some pointers to keep in mind is the option which is more closer to your principle, the option which is more aligned to your principle, the option which explains your principle in a better manner. These sort of options out of the 2 are surely better options and most likely the correct answer as well. उसके अलावा the basic fundamental principles of logical reasoning also apply to a certain extent in these type of questions, जैसे कि आपके जो वेग ऑप्शंस होंगे वो डेफिनेटली गलत होंगे, आपके जो एक्सट्रीम ऑप्शंस होंगे इन मैक्सिमम केसेस वो गलत होंगे, आपके जो आउट ऑफ द स्कोप ऑप्शंस होंगे वो मैक्सिमम केसेस में गलत होंगे. सो वो बेसिक चीजें आपको कॉमन सेंसिकल वाली बातें सारी ध्यान रखनी है व्हेन यू आर अप्रोचिंग प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस. नाउ द नेक्स्ट थिंग इज आपको प्रिंसिपल पहले पढ़ना है या फैक्ट पहले पढ़ना है. नाउ when I teach logical reasoning or English, I suggest reading the questions first. But in legal reasoning, I don't suggest that. I suggest that you read the principle first and then move on to the facts. Because जब आप facts पहले पढ़ोगे तो आप assume करोगे कि principle क्या होगा and your biases, your predefined knowledge might mislead you into the wrong option. तो मैं चाहता हूँ आप पहले प्रिंसिपल पढ़ लो, फिर उस प्रिंसिपल के अकॉर्डिंग सोचो और उस प्रिंसिपल के अकॉर्डिंग उस फैक्ट सिनेरियो को जज करो. सो दैट इज द मोडस ऑपरेंडी, दैट इज द वे यू अप्रोच प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस. ठीक है, पहले प्रिंसिपल रीड किया, उसको समझा. कई बार होगा आपने प्रिंसिपल वो नहीं सुना होगा. देयर माइट बी अ प्रिंसिपल व्हिच इज लेट्स से फ्रॉम द मोटर व्हीकल्स एक्ट और फ्रॉम फैमिली लॉ और फ्रॉम कंपनी लॉ. Anything, it could be any principle. You just need to take it on your face value, on its face value, and just look at it as a sentence, as a guiding light कि हाँ ठीक है ये बात कही है, मुझे इस बात को अप्लाई करना है बस फैक्ट सिनेरियो में. अब आपको वो लॉ आता है, आपने वो लॉ पढ़ा है नहीं पढ़ा, दैट इज इममटीरियल. ऑब्वियसली इट इज बेनिफिशियल अगर आपको वो चीज आती है तो आपको थोड़ा सा फेमिलियरिटी रहेगी एंड यू वुड बी बेटर इक्विप्ड टू अंडरस्टैंड द प्रिंसिपल एंड फैक्ट्स. बट अगर नहीं भी पता तो still doable. ठीक है, then of course you would read the fact scenario and then the options and then you would evaluate कि principle जो है fact scenario में किस तरीके से fit हो रहा है and कौन सा option best suitable है based on the criteria which we just discussed. ठीक है, अब important things to study में चार चीजें आ जाती हैं when you talk about the subject of legal reasoning. There are 4 subjects which you need to study. स्टडी में भी बहुत डिटेल्ड स्टडी आपको नहीं करनी, जस्ट नीड टू नो द बेसिक्स ऑफ 4 सब्जेक्ट्स. व्हाट आर दीज 4 सब्जेक्ट्स? लॉ ऑफ टॉर्ट्स, लॉ ऑफ क्राइम और क्रिमिनल लॉ, कॉन्स्टिट्यूशनल लॉ और द इंडियन कॉन्स्टिट्यूशन, एंड द फोर्थ इज लॉ ऑफ कॉन्ट्रैक्ट्स. ओके, so torts, crime, constitution and contract. We'll also start either one of these in most likely the next class. So that is the agenda. We will cover most of it in our classes as well. So make sure you are regular to the classes. And yeah, that is what is important to study. Apart from this, there are miscellaneous things like legal maxims, legal terms. वो सारी चीजें हम साथ साथ में करते रहेंगे. ठीक है जी, सो ये तो हो गया आपका सिलेबस पॉइंट ऑफ व्यू एंड प्रिंसिपल फैक्ट बेस्ड क्वेश्चन करते कैसे हैं. अब ये क्वेश्चंस दिखते कैसे हैं, व्हाट आर द क्वेश्चंस like? So let's move on to that. Let's start solving some questions. It's okay if you answer them incorrectly or if you give the wrong option, that's completely fine. This is just a practice exercise to tell you how questions are framed. So don't worry about wrong answers. Let's just go. Okay, so the first question, legal principle is an agreement entered into by way of a wager or bet is unenforceable in law. ठीक है, तो अगर कोई एग्रीमेंट ऐसा है जिसमें आप वेजर या बेट लगा रहे हो तो वो अनएनफोर्सेबल है. अब एक मैं क्वेश्चन आपको करके दिखाता हूँ, नेक्स्ट क्वेश्चन से आप लोग सॉल्व करना. थॉमस इज वेरी गुड एट प्रिडिक्टिंग आउटकम्स ऑफ क्रिकेट मैचेस. राजा एंड होजा गिव हिम ₹1000 each to enable him to bet with others about the outcome of the cricket match. Thomas wins ₹3 lakh after betting ₹3000. Which of the following is most appropriate in relation to the legal principle above stated? Thomas must share 3 lakh with Raja and Hoja equally. Thomas must return ₹1000 each to Raja and Hoja. Thomas need not share the 3 lakh with Raja and Hoja since it is an outcome of an unenforceable agreement. If Thomas does not pay them ₹2 lakh each, Raja and Hoja can sue him to recover their share. अब देखो प्रिंसिपल हमें अप्लाई करना है. प्रिंसिपल में कीवर्ड्स देखो क्या है, एग्रीमेंट, वेजर बेट, अनएनफोर्सेबल इन लॉ. 3 कीवर्ड्स हमें दिख रहे हैं, करेक्ट. ये कीवर्ड मुझे किसी ऑप्शन में दिख रहे हैं? हाँ, मुझे सिर्फ ऑप्शन नंबर 3 में दिख रहे हैं कि आउटकम ऑफ एन अनएनफोर्सेबल अग्रीमेंट. क्या ये बात सच है कि दिस इज एन आउटकम ऑफ एन अनएनफोर्सेबल अग्रीमेंट? यस, क्रिकेट मैच में बेट करना दैट इज अनफोर्सेबल, राइट, अनएनफोर्सेबल. आप प्रिडिक्ट नहीं कर सकते कि क्रिकेट मैच में क्या होगा, सो इट्स अ वेजर, इट्स अ बेट. तो इस वजह से दिस इज अनइन्फोर्सिबल इन लॉ। आप इसको एनफोर्स नहीं करा सकते, आप इसकी रिकवरी नहीं कर सकते। एंड थॉमस को कोई ऑब्लिगेशन नहीं है उनको 1 रुपए भी वापस करने का, और 3 लाख रुपए वापस करने का तो बिल्कुल नहीं है। So what would be our right answer? The right answer would be option 3, that he does not need to share the 3 lakh with Raja and Huja since it is an outcome of an unenforceable agreement. And enforce ही नहीं करा सकते आप, कोर्ट ऑफ लॉ में जाके नहीं बोल सकते कि मुझे ये अग्रीमेंट मैंने साइन किया था, मुझे इसका रिवॉर्ड चाहिए. So that is how you apply a legal principle to a fact scenario and then to the options. ठीक है? Okay, moving ahead. Next question. Giving you guys 30 seconds to do this. Okay, let's check. Legal principle says when there is an infringement of the legal right of a person, he gets a right to sue the wrongdoer for remedy irrespective of any actual loss caused. Saroj is prevented from voting at an election. That means legal right has been infringed. Candidate she intended to vote for wins the election. That means there was no actual loss, but there is still the right to sue the wrongdoer, right? So let's check. Which of the following statement is the most appropriate in relation to the legal principle stated above? Saroj's legal right has been violated and she can sue the person who prevented her from voting. Yes. Since Saroj's candidate has won the elections, her rights are not violated and she cannot sue. No, rights are still violated. Loss nahi hua koi, but she can still sue. Since Saroj is not the candidate, her rights are not violated if she is prevented. No, candidate होना जरूरी नहीं है. The principle is not at all applicable. ये तो बिल्कुल ही गलत है. So option number 1 becomes the right answer. This particular case scenario is derived from a very famous case, a landmark case called Ashby versus White, जिसमें same fact scenario होता है. And उसमें ये decide हुआ था कि you can claim damages. This is a famous case of law of torts. इसको हम बोलते हैं इंजूरिया साइन डैमनम, यानी कि इंजरी हुई बट डैमेजेस नहीं हुए. सो इंजूरिया साइन डैमनम का ये सबसे अच्छा एग्जांपल है, ये वाला केस वोटिंग वाला. ठीक है, चलो लेट्स मूव ऑन टू द नेक्स्ट क्वेश्चन. अग्रीमेंट्स इन रिस्ट्रेन ऑफ ट्रेड आर void and unenforceable. 30 seconds. Done, guys. Easy question. Chalo, let's check. Manu has been working as a blacksmith in his village for many decades. Somu has been undergoing training with him for past 3 years. After his training is over, Somu enters into an agreement with Manu that he will not start a competing business in the same village while Manu is alive. Okay. Which of the following is most appropriate? Agreement is void and unenforceable since it is a restraint on trade. Yes, it is. Agreement is valid and enforceable since Manu is Somu's teacher. No, that is irrelevant. Agreement is valid but not enforceable after Manu's death. Not really. Agreement is valid and enforceable since it is to protect Manu's interest in consideration for teaching Somu to be a blacksmith. नहीं, ऐसा कुछ नहीं है. Option number one becomes the correct answer. कि आप ट्रेड से नहीं रोक सकते because that is what your principal says. ठीक है. Let's do next one. Question number 4. This is very simple, very straightforward and direct. The principle says property can be transferred only by a living person to another living person. Fact is, A transfers property to which he is the owner in favor of the unborn child of B, which is not a living person. So property has been transferred to the unborn child? No. Property has been transferred to B? No. Property has not been transferred to the unborn child? Yes. Property will be transferred after his birth? नहीं, ऐसा कुछ नहीं होता. Either it happens or it does not happen. So option number C, right answer. Simple. Let's do another one. Okay, let's check. Terms of any written contract can be proved by producing the written contract only and oral evidence is excluded. A gives B receipt for money paid by B. Oral evidence is offered to prove payment, but can it be used? No, it cannot be used. Oral evidence is excluded. You have to prove it through the written contract only. So, what is the right answer? Oral evidence to prove payment is allowed? No. Oral evidence to prove payment is not allowed? Yes. Oral evidence is always allowed to prove all facts? No. Oral evidence is generally disallowed? No. Option number B is the most appropriate one. Let's do another one. Question number 6. Okay, let's see. Employer is liable for the injury caused to the employee in the course of his employment. X organized a party and hired a caterer. During the party, his generator went out of order and he requested one employee of caterer. Important. That is Y to bring the mechanic on his vehicle and promised to pay 1,000 for the same to Y. Y met with an accident while going to fetch the mechanic and he seeks compensation. Now, injury has been caused to the employee in course of employment, all conditions fulfilled. You have to determine Who is going to be the employer? Is it going to be X or is it going to be the caterer? X is liable as Y was working in the course of employment offered by X. Okay. X is not liable as Y is not his employee. X is liable because party was organized by him. ये तो बेकार option है चलो. Caterer is liable as Y is his employee. Now figure out. Requested one employee of the caterer. Organized a party. During the party, he promised to pay 1,000 the same to Y. Now, would X be liable as Y was working in course of employment offered by X, or would the caterer be liable? Would it be option A or option D? X is not liable as Y is not his employee. ये तो चलो not की बात कर रहा है. हमें most appropriate answer देना है. So the most appropriate answer would be the caterer being liable as Y is his employee, right? Because employer is liable. Direct employer caterer है. Caterer को employ किया है X ने. So even though he has paid him 1,000 rupees, that does not make him his employee. Employee वो caterer का है, तो caterer ही liable होगा accident के लिए, ठीक है? Okay, let's move on to the next question. Question number 7. Similar principle. Master is liable for the acts of his servant done in the course of his duties. Okay, let's check. X had an employee, Y, in his construction business. Y was the property in charge who received construction material and gave receipts for the material received by him. Z claimed payment for cement supplied to X. So Z ने X को cement supply किया है, which was duly received by Y. Duly received by Y. X denied the payment on the ground that he had only received half of the material and the balance was misutilized by the employee Y. Okay. X is liable for the entire amount. X is liable for the part amount only, that is payment for half the cost of the material. X is not liable for the misconduct, embezzlement of his employee. Yeah, Z can claim the balance payment only from Y. देखो Y से तो claim नहीं होगा, वो तो employee है. X is not liable for misconduct, embezzlement भी नहीं होगा. He would be liable because master is liable for the acts of his servant done in course of duties. अब क्या वो एंटायर अमाउंट के लिए लाइबल होगा या सिर्फ उतने के लिए जो हाफ ऑफ द कॉस्ट ऑफ मटेरियल? अब हाफ ऑफ द कॉस्ट ऑफ द मटेरियल से जेड को क्या फर्क पड़ता है ना? जेड वांट्स हिज एंटायर पेमेंट, सो एक्स वुड बी लाइबल फॉर द एंटायर अमाउंट बिकॉज वाई हैज रिसीव्ड द एंटायर कंसाइनमेंट एंड मास्टर इज गोइंग टू बी लाइबल फॉर हिज सर्वेंट, सो ही इज लाइबल फॉर द एंटायर अमाउंट बिकॉज ही इज द मास्टर ऑफ वाई. ओके, so that brings us to the end of today's class and practice questions. I hope this was a productive session. This was a very basic sort of introduction to principal fact-based question. We'll slowly progress and move to tougher questions, tougher concepts, but that is in due course of time. In the next class, we'll probably start a new concept. So stay tuned and subscribe to the channel if you haven't yet. And do drop a like on this video and I'll see you in the next one. Till then, take care, keep learning, keep preparing. Bye-bye. Signing off.